Hi there, this is Attorney Kelly Hunt with another video in my will series. With this one, we've stepped up into the Wills 103 category with my Transfer on Death talks. This specific video is on Transfer on Death deeds. Now, the Transfer on Death talks are a little bit more of a quasi-will situation with specific types of property, usually with either a deed or a title to a car. The Transfer on Death deed is specific to real property that you have an interest in, usually a marital home, mineral interest, or something along those lines. For a Transfer on Death deed, you create a deed, and within that deed is a language on who you want to have those assets when you die. For instance, if you own mineral interests and you have 3 children, you don't want it to go through probate and you just want those interests to go to your children after you die, you can create a deed that says, upon my death, I want my mineral interest to be distributed equally to Susie, James, and Joe. What I urge people to do, though, if you have more than one person you are trying to include on the Transfer on Death deed, be extremely specific on what else could possibly happen. Let's say, for example, one of your children passes away, or one of the people you're trying to leave the property to passes away before you die. You really should anticipate that, no matter who the person is, how old they are, because freak things can happen. So what I highly recommend doing is saying, Susie, James, and Joe, or to the remaining of the 2, or the remaining of whoever's left after I die. Or you can say, or to anyone who's passed away before I die, to that individual's estate. You do this just to make sure that there's no question, because you can't really have any what we call ambiguity when creating these types of deeds. Otherwise, it's going to kick it into a probate situation, which is what you're trying to avoid. So with a Transfer on Death deed, you do have to meet the normal requirements of a deed, which it has to be signed and notarized, and then you have to record it. The nice thing with this, though, is it's not what we call a present-day transfer of the property. You still own it, which means that you can sell it. You can sell all or part of it. You can put a mortgage on it. You can revoke the Transfer on Death deed and do another one. You can still do whatever you want to do with the property. Whereas if you do a life estate or if you do a present-day conveyance, it's not yours anymore. And whoever you're really giving it to can do whatever they want with it, with the nuances of a life estate, which we'll cover in another video. So that's one of the nice things about a Transfer on Death deed. It's also a much easier process for the people that you want to leave the property to be able to collect it. Again, there's no probate unless there's a question. So all the beneficiary or beneficiaries have to do is within 9 months of the date of the grantor's death, they have to do a beneficiary affidavit, attach a copy of the death certificate, and record it. And then that individual has officially claimed that property as their own. Now, for any beneficiary that doesn't do that within the 9 months, or if the beneficiary has predeceased and there's no directive there on what to do with it, that portion of the property does become what we call an estate asset, and that portion of the property would have to be probated. So if you have Susie, James, and Joe, and James predeceases, and we don't know what happens to that property because there's no directive, or Hi there, this is Attorney Kelly Hunt with another video in our will series, Wills 103 Transfer on Death deeds. A Transfer on Death deed is a quasi-will which specifically relates to real property. And normally when we're using these, we're talking about, marital homes, maybe other land, possibly mineral interests. And these are a way of avoiding probate by essentially creating a distribution clause within the deed so that when you pass away, we know automatically who the property is going to go to. So you avoid probate, and it's a much more simplified procedure for the beneficiaries to be able to claim their property. So really what you do have to do with a Transfer on Death deed is it can be typewritten, but it does have to be signed, dated, and notarized by the grantor, the person wishing to will the property away. You would then put clauses in there about who gets the property. If you have one person, it's relatively easy. I want the property to go to Jane Smith. Upon your death then, within 9 months, Jane Smith just has to file a beneficiary affidavit and a copy of the death certificate with the county land records, and then Jane Smith owns the property. If you have more than one person you want the property to go to, I don't necessarily recommend having multiple owners, especially multiple non-married owners of the same property, because then you can create issues if they ever want to sell it, mortgage it, do something along those lines. But if you want to do that, say you want to leave it to Susie, James, and Joe, you can put in there that I want the property to go to Susie, James, and Joe. But be very specific when you're dealing with more than one person. Say you want it to go equally, or if one of these people predeceases me, it's to go to the other two people in that person's estate, or the property is going to go to the survivor of any of the three of these if they predecease me. You want to be extremely specific, because if it's not, and we can't tell by the face of the deed what you want to do, that's kicking you into a probate situation. Also, if we have either the more than one person or even the one person, remember I said they have 9 months to accept the property. If any person, including one person or one of your multiple, does not do that, it kicks that property into a probate, and we will have to go through that procedure in order to have it distributed. For example, if you got Susie, James, and Joe, and James does not accept the property within that 1 month period, that part of the property would have to go through probate and then distribute it. So you really do have to be very, very specific when you have these types of conveyances. Also, if you do currently own your property with somebody else, say a spouse, and it's as joint tenants with rights of survivorship, meaning when one person passes, it automatically transfers over to the survivor, the transfer on death deed would not come into play until the last survivor passes away. Now, for the transfer on death deed, and especially when you're dealing with that kind of survivorship clause, you can actually revoke a transfer on death deed at any point in time. This is because you never lose ownership of the property. You can still sell the property. You can still mortgage the property. You can do a home equity line of credit on the property. You retain ownership. It's not until after you pass away that the ownership would transfer. So it's a little bit better of a mechanism than maybe a life estate deed or a present day conveyance. But if you own it with somebody as joint tenants with rights of survivorship and you pass away, yes, the surviving joint tenant can revoke that deed and can put a different transfer on death claim out there. If you have that kind of situation, and honestly we usually run into this more with blended families, maybe step parents, or that type of situation, I would tend to recommend more of a will or a trust, having the joint owners put it into a trust so that you can make sure after you pass away it goes directly to who you want the property to go to, because that's really going to be the only way to do that. But this is your transfer on death deed. You do a deed, you put in there who you want the property to go to, you record it, and then you can revoke it, you can do whatever you want with, but just be very specific. If you have any questions on doing a transfer on death deed or how to handle it with your real property or how it may benefit you, please feel free to give me a call. I'm at McDaniel Acord with 918-382-9200.